Pietermaritzburg High Court judge, this is Piet, yesterday finding that Zuma failed to provide evidence of prejudice if Downer led the prosecution. Let's talk now to how we arrived at this point. Joining us is legal journalist from News 24, Karyn Maughan. Karyn, very good morning to you. So let's just have a look at this case in its totality. In your view, is President Jacob Zuma likely to succeed, as his team has already indicated that they are going to appeal yesterday's ruling, and many people questioning when is he actually ever going to have his day in court?
Well, Corley, first of all, I don't think Jacob Zuma has any prospects of success of convincing either the appeal court or the constitutional court, if he goes that route, to hear any challenge that he brings in relation to this judgment. That's for a number of issues. First of all, the application that he brought under the Criminal Procedure Act for a so-called special plea, as Judge Piet explains very carefully in his judgment, is fundamentally legally flawed and misapplies the Criminal Procedure Act in terms of how that particular section works. But in addition to that, the issues that he's ventilated, these 14 different complaints that he's raised against Downer as a basis for saying that he lacks independence and is biased against him, have all been ventilated in multiple courts multiple times before. These are not novel issues. And in every single case, whether it was the spy tapes matter or the Nicholson overturning in the appeal court, the courts have continuously said that Jacob Zuma can and should raise his conspiracy claims and his fair trial rights violation claims, but he needs to do that during his trial, because ultimately it will be the trial court that is best placed to ensure that his fair trial rights are protected.
Yeah. Karyn, the next question is one that you and I think, will cringe when we hear such news, and that is journalists becoming news. This is something that we always try and avoid, and unfortunately you became party to that last week Thursday when the former president went to lay a charge against Billy Downer in Pietermaritzburg. Your name specifically being mentioned by Jimmy Manyi, or Mzwanele Manyi as it goes nowadays, and specifically saying that you received documents which are assumed to be medical records of the former president, and this is partly why he felt it necessary to mention your name. What did you receive? From whom?
Well, I mean, that allegation is completely incorrect, and this matter was dealt with very carefully by the court yesterday, because it was one of the bases for the former president arguing that, the prosecutor, Billy Downer, should not be allowed to prosecute him or try him for corruption. The state has laid out what exactly occurred. I had approached Andrew Breitenbach, who is the counsel for the state in the in the special plea application, when there was going to be a postponement of the special plea, and asked him for documents that would be filed as part of that application. He provided me with both the unsigned affidavit of Billy Downer and the defense's application for a postponement, which contained a single-page letter from Jacob Zuma's military doctor stating that he would require 6 months of treatment because of a traumatic injury that he had sustained, which may or may not have possible implications for his trial. Judge Piet yesterday saying that, the letter in itself did not contain any confidential medical information. These were part of public documents that were filed at court. The story was only written when those documents were filed. And the judge really saying that at this point, what happened there, which, was really an exchange between myself and Breitenbach, Downer, while he knew about it, was not directly involved and certainly didn't leak me any medical reports. It was simply a matter of what court journalists do every day, and that's obtain court documents so we can report accurately on cases.
Yeah. Now that Judge Piet, Karyn, has ruled that the disclosure of this information did not constitute a violation of former President Jacob Zuma's rights. Do you believe you now have permission to report fully about the information that you have in your hands?
Well, I don't have any information. The only information that I have literally is court documents. You know, the impression that is created that I have access to medical records is simply not the case. And that is not what happened. All I did was obtain court documents in a case that was fully argued in court. We know that the state was not satisfied by the level of explanation that was given by the former president's doctor, that they felt it was vague. We now see a situation playing out which seems to be on hold in relation to whether the former president, will be examined by NPA doctors if there is any further attempt to postpone this matter because of ill health or, a question of his fitness to stand trial. But certainly there was no handing of medical records to me at all. That is simply untrue. All I did was get court papers in a case that was fully argued. And certainly, if there is a case to be brought in relation to the former president's state of health, as there have been in other criminal matters, that case will be held in camera. And those court documents will not be available to the media because of the kind of privacy issues that surround them. But those issues are not at play here. And I think that, there has been quite a fundamental distortion of what happened here. And misrepresentation, but certainly, I don't have any records, and even if I did, and I don't, I would certainly, there would be serious ethical concerns about reporting on someone's state of health, if there wasn't a clear legal directive to do so.
How do you respond to those who say what the prosecution team that is handling this matter, what they did by giving you this information was, one, unethical, and then you heard in court Dalimpofu arguing that you may also have received some coaching around how to report on this matter. What's your response to those claims?
Well, the former president's team knows very well that I often ask them for court documents. It's part of what legal journalists do. Court documents are public documents. Any member of the public, if you are interested in a case and you want to see what the arguments are, you can go to the court, to the registrar's office with the case number and get those court documents. You will know that I've made a habit, oftentimes not recently, but to put out judgments, to put out affidavits. They are public documents, they are sworn statements, and they give us insight into the arguments that are being made in very important cases. So there's absolutely nothing unethical about what happened. At the time that I wrote those stories, the story in question, the document had been filed in court, and certainly there's nothing untoward about it. And ultimately, it's about responsible journalism. I don't want to get lawyers' versions of things. I want to hear exactly what the arguments have been made. In relation to the coaching point, that was because there was an agreement between myself and the state that I would only publish my story once the documents had been filed at court, which I did. That is not coaching. That is simply, adherence to a proper ethical and legal standard of journalism. Yeah. So, I think that there's been quite a fundamental misrepresentation, and I do understand, from looking at the arguments that are being made, that the former president very much feels aggrieved by this. But he himself has gone out on public forums, for example, on his the Zumas interview with his son in May 2020, to ventilate issues around his alleged poisoning and the fact that he received treatment in Russia. He has often put his medical condition at the forefront of certain conspiracy claims that he has made. He claimed in the Zondo inquiry, for example, that he'd been poisoned or was being targeted by foreign and apartheid spies. So, there seems to be in certain circumstances, the weaponization of these health issues.
Oh, no.
To have them interrogated.
You froze there for a moment, Karyn. Perhaps it's a signal for us to start wrapping up. Very briefly for me, if called upon to testify on this matter, you will know that the former president has gone and laid a charge. It might go to court. Will you testify?
I would obviously have to, speak to my bosses at News 24, and we would have to get legal advice on this. But, I don't think that anyone did anything wrong here. And I think that the court has found that very, very strongly in its ruling. And the judge even questioning while saying that, obviously this matter needs to be properly ventilated, that he did not necessarily see interactions between a journalist and a prosecutor as being an unlawful act. But, ultimately, if the NPA decides to pursue that, I believe fundamentally that we are all equal before the law, and I will adhere to the processes, on the advice of my bosses and on the basis of what is ethical, constitutional, and lawful.
Yeah. Karyn, final question to you, and very briefly, if you can. You will know that the DA has gone to court seeking access to the record of the Correctional Services decision to release the former president on medical parole. What do you think is at play here? Do you think all of this has to do with the former president perhaps fearing that people might find out what the actual state of his medical health is?
Well, there's a clear legal challenge in relation to the awarding of medical parole, which on the face of it does seem to be extremely problematic in that it was done against the advice of independent medical experts on the medical parole advisory board. So, my understanding is that some parts of the record have been received. I know that the DA was attempting to litigate, but I'm not sure if they're pursuing that, or if they're just going to go on with the records that they have. The issue is this: medical parole and the use of health issues to, in some instances, get premature release from prison, and in others to potentially evade accountability in certain accountability mechanisms, not least of all of the courts, has unfortunately been a feature of our life over the last 2 decades. And it is crucially important that if these processes are going to be utilized, they be open to public scrutiny in a way that protects the privacy of the accused person, but also ultimately serves the public good of making sure that medical parole is not utilized to simply serve as a mechanism for the politically well-connected and elite, but ultimately for prisoners who are desperately ill and should be given time to go home and die with their families. That's really ultimately what medical parole should be used for, and hopefully these court processes will ensure that the standards are put in place to make sure that that happens.
Karyn Maughan, thank you very much for your time. She is a legal journalist with News 24.